So, hi folks, Alex Woods from Court Wingman here, vlogging to you on a beautiful autumnal day just outside the Royal Courts of Justice on the Strand in London. Now, I've been vlogging for, 15 odd years, but I've never actually done a complete case study of an entire set of proceedings. For various reasons, perhaps client confidentiality, perhaps it just probably ultimately wasn't a really good case study, and very few cases go to trial. So I've decided to do a case study for litigants in person and for junior lawyers who want to learn about the dogfight that is civil proceedings, and in this case trial, by means of this, by taking this one single case. Because this case is just jam-packed full of civil litigation knowledge. Not only the law, although it's an excellent kind of primer or introduction or insight into the law of trusts. Anybody who's got a contested will type case or a property law case, a family dispute, which is what this is. The law of trusts, or the law of equity, is a very interesting area of law, but not just, it's not really just about that. It's also about, it's just being like a gift that goes on giving in terms of pretty much everything that can happen in a piece of civil litigation has happened in this case. And we're up against a litigant in person too, so it's got really invaluable insights for litigants in person running their own cases, and it's been running in the courts for nearly 5 years. It's approximately £200,000 dispute. I vlogged about that in a previous vlog. It's a dispute between a grandmother, our client, who's now deceased. She died during the course of proceedings, unfortunately. And it raises a big question for me personally, which is the legal system fit for purpose? This is a case study that puts the civil justice system itself under the spotlight. Because this is perhaps one of the most morally wrong cases I've ever dealt with. And I did a lot of financial mis-selling litigation cases against the banks. And yet there's a serious risk we might lose. It's on a knife edge. I'm going to cover all of those topics, that one in particular, as well as the law, but as well as a whole host of procedural topics that I've listed down here. There are probably a good 15 of them. So I'm going to use this as a case study. So it's a real life case. You'll get to know the story of the case, and then I'll do little sort of more bite-sized vlogs on a plethora of different issues, running from costs, precedent H's. Can I disclose documents very late? Can I change my case? What happens at interim hearings? Do I need a barrister? Do I need to instruct a lawyer? If I'm a defendant, should I actually defend a case in my own name as a litigant in person? Is the Central London County Court fit for purpose? Is it overstaffed and under-resourced? And are you a hostage to fortune if you're going to bring a claim in the Central London County Court? It certainly can feel like that. So I'm going to cover all of those topics and more. But today I just wanted to say that, just kind of give you a feeling from the trenches, as by way of an introduction to this series of vlogs, and just communicate to you how it feels for me as a solicitor running what has probably been the most challenging piece of litigation I've had to deal with in living memory. One of the things that I major on my channel is the importance of being ready for battle having a war chest, but most importantly being prepared and mentally prepared, as well as prepared in terms of your documentation. I feel that I've never said a truer word. I feel that if you're not, and it gets all the way to trial, you will be found out. We have really been challenged at every step of the way by an extremely determined, tenacious and smart litigant in person who does not want to repatriate what we say substantial amount of funds, properties in particular, that she misappropriated from her grandmother, who set up a trust for the granddaughter to provide for the granddaughter, the granddaughter's brother, grandson, as well as for her. Basically, she owned about 15 years ago, give you a quick skinny on the story, grandma owned two properties, a family home in London and a smaller home, and she'd left the big one to the grandson and the small one to the granddaughter, and she, in her will, and she was bringing a will forward in her lifetime to help out the granddaughter get a foot on the property ladder. This is so difficult for young people these days. But the arrangement was that the big property would go to the grandson as per the will, and the granddaughter would get the smaller property. Anyway, the long and the short of it is, over a period of 10 odd years, the grandmother invested sort of a power of attorney in the granddaughter. She was a trustee, we say, although nothing was written down, and she was a trustee to look after her grandmother and her grandson. Her grandmother downsized to a smaller property, but unfortunately it hasn't turned out that way. The granddaughter has ended up owning outright the family home, which she sold last year for £925,000, walked away with about £750,000 to £800,000 equity after the mortgage is taken out. And she owns outright a smaller property, which also has a mortgage on it, but which has a lot of headroom in terms of the equity on that too. So she's ended up with everything. That property, she's probably got £400,000 equity in, so she's a millionaire. Although when I pointed that out, she responded in a rather outraged way, at least by email. And her brother, she paid off. He was a youngster. Well, he was at university. She's an older sister, and she's paid him off over the years, last 10 years, £140,000 to come off the title deeds of the family home. And she's, as I say, so she ended up owning everything apart from £140,000. The smaller flat that our client, the grandmother, moved downsized to, so that the granddaughter and the grandson could move into the family home. She was forced to sell because she couldn't afford the mortgage payments, and anyway it was mortgaged up to the hilt, we say, by the granddaughter, and she died with very little to her name, so that actually during the course of these proceedings we flipped over to no win no fee, because it just felt so morally wrong. But the fascinating thing about this case is this, and this is why I feel it's like putting the system under the spotlight, kind of in a way, as exhausted as I am from running this case. I couldn't warrant for a better case in terms of putting the justice system, at least the civil justice system, under the spotlight. Because this is a case where it just feels so wrong what's happened, and yet because of various factors, it's touch and go. It's sort of 50-50. Obviously the client has died. That doesn't make it easy. We've not got a witness. We're representing the estate, the executor in the estate. But also, there's a paucity, a lack of documentation. It's been a long time. And the litigant in person, to her credit, she should train to be a lawyer after this, has pulled out all the stops and obliged us to spend a lot of time, money and energy on a no-win, no-fee basis, so we're not getting paid, to deal with a zillion little interim hearings, amendments, changes, objections, vacations. You just wouldn't believe. So it's been the ultimate test as well. But to come just to focus on this point, this is the question: in what's quite what feels like a morally wrong thing that's been done about what we consider to be a classic example of entitled Britain, the youngsters feeling that they're entitled to everything, getting away with everything, and yet the law, procedure, the complications, the delays, the judge, the barrister's not very happy with the particular judge we've got because he's quite geeky and he'll focus on the fine print and the technical side of the law, whereas I feel as if we had a jury, it'd be a slam dunk, and we'd win. And that just makes me think of another quite famous case that took place here not so long ago, and that was the Johnny Depp and Amber Heard trial, which I took an interest in and did a vlog on. Because you may not know that the first libel trial took place here, the Royal Courts of Justice. And then the one that everyone knows about from the news, or at least the one that's, if you're North American, you'd never have heard about the British libel case between the two of them. The one that took place in the States, that was a resounding victory for Johnny Depp, and it was a jury trial. Now, we don't have juries in libel cases any longer, except in exceptional circumstances. And I read the judgment, and Johnny Depp lost here at this trial, as I say, that took place before the American one. And he lost because, it was just a single judge who applied the law, pretty strictly, and you could argue very sensibly, but it feels as if, in terms of the bigger picture, justice wasn't really done. And I feel that this is a similar case. So I'll leave it there for today. This is just an introductory vlog. Those who've been following me know that, I go back some time in terms of vlogging. I first started vlogging during the financial mis-selling crisis, PPI, interest rate swaps, in around about 2008. And in fact, I made a brief appearance on BBC's Rip-Off Britain, with Angela Rippon and Gloria Hunniford, about that scandal, because I was running these cases at the time. And this feels like another chapter in the evolution of British society, because in this case it's more like, in inverted commas, entitled Britain, exclamation mark, close inverted commas. Because it really does feel to me as if poor old grandma, bless her, should be looking down at us right now, will be wondering whether or not her granddaughter is going to get away with it. So remember, we're at trial after 4.5, 5 years. If you're contemplating litigation as a litigant in person, or instructing lawyers, or using a support service like Court Wingman, got a little plug in there, do remember that you've got to be prepared to go all the way. So from the very beginning, you've got to plan ahead, and it's not just financial, and a paperwork preparation I'm talking about. It's about the mental preparation. So my job, by the way, I happened to be here for the trial, 4-day trial. This is the first day, and it's a reading day, so everyone's reading the documents. My job really is now downgraded to bag carrier for the barrister. I'll touch on this topic as well as the others, because actually a solicitor's job is in that preparatory stage They're like the producers of a movie and barristers like the actor. Let's see how it goes. It's day one of a 4-day trial, Royal Courts of Justice, Central London County Court, the Strand. Goodbye for now, folks.